face-to-face meeting. So the way it's going to work today, Chris, as I say, Chris is my fellow employment lawyer in Fretton, so Chris can have a little wave there. Hopefully you might be able to see him. There you go. We're going to sort of go backwards and forwards through the session. As I say, the main part of it will be a case review of last year. We are deliberately not focusing on furlough, which hopefully most of you will be pleased to know. We probably did it to death last year. We have noticed a huge drop-off in inquiries about furlough, which is understandable because the last major change, which I will mention, was back in sort of end of October. So we are deliberately not focusing on furlough today. Having said that, if you do have any questions on it later on, then please do feel free to ask them, and we will obviously cover them off. So as I say, the main part of the presentation will be a review of the important cases from 2020, and then also looking forward to, it says on the slide, definite changes. That will be very quick, I think Chris will agree. But then what else to watch out for in 2021, and that's when we're going to talk about a couple of particularly hot topics at the moment that we're getting quite a few inquiries on, and there's a lot of debate about. And then finally, as I say, there will be questions. Okay, so without further ado, I think we'll start now properly. So if we can move on to the January. So the way we're going to do this is we're literally going to go through the year and pick out key cases as they came up. As I said, if you've got any questions at any time, then please do put them in the chat, and we can open your mic up and take it from there. So January, there was a couple of key cases. The first one was a very high profile case. It was all over the news, particularly the BBC, as it involved them. And I don't know how many of you know Samira Ahmed. She, I actually have watched it on a number of occasions. She presented, well, as far as I know, still does, Newswatch, which is a short programme on Sunday mornings, a bit like Points of View. And that's where it becomes interesting, because she brought an equal pay claim against the BBC because of her pay disparity with Jeremy Vine, who did present Points of View. So as you probably mostly know, the Equality Act gives basically equal pay rights between women and men for equal work. It basically implies a sex equality clause into every contract of employment to ensure women's contractual terms are no less favourable than men's. So that's the starting point in the Equality Act. It goes way back to the Equal Pay Act from the 1970s. Miss Ahmed claimed from October 2012 right up until the current date that her work was equal to Jeremy Vine presenting on Points of View. However, she was only paid £440 a programme, whereas Mr Vine was paid £3,000. So obviously a big disparity there, and she claimed that the sex equality clause was engaged and that she was treated less favourably in terms of pay. Now, an employer does have a defence to an equal pay claim if they can show there's a material factor other than gender that explains the difference in pay. And the BBC tried to rely on 5 factors. The first was the difference in profile between Newswatch and Points of View. Basically, they said Points of View was a lot more high profile than Newswatch. Similarly, differences in the public profile and the level of audience recognition between Miss Ahmed and Mr Vine. Basically, they were saying that Jeremy Vine was more famous than Samira Ahmed. Differences between the market rate payable between the two of them at the time, and the market pressure was different when Mr Vine negotiated his terms of pay as opposed to when Miss Ahmed did hers. And finally, the types of contract they were engaged on. They tried to say they were different contracts. So that was the defence that the BBC put forward. And to sum it up, basically, the tribunal disagreed with them totally. They basically said that the two programmes were like work, broadly similar, and that the same skills and experience were required to present both programmes. In particular, there was one comment the BBC made about a glint in the eye and a cheeky look And the tribunal said they couldn't understand why the BBC even brought that up and how that had any sort of material difference at all. Also, and it was quite a long judgment, but the main thing was that the difference in pay was so striking. It was a huge disparity of £440 to £3,000. And also the BBC didn't have a transparent pay structure, okay, for determining pay and recording the rationale. So when it came to the tribunal and the evidence, they couldn't actually show transparently really a real difference in the pay, okay. There was no evidence also that the profile of either the programmes or the presenters was actually taken into account by the BBC when they set the level of pay. That was just something they tried to bring up at the tribunal as a difference later on, but it never really entered their mind at the important point of setting the pay. So basically they failed in all counts, and Samira Ahmed won her case, which is why it was all over the news. It's seen as a landmark ruling. I'm not so sure it is a huge landmark ruling. I think it's actually fairly common sense, and I'm surprised the BBC actually didn't try and settle it before it got all the way to the decision. But importantly for you as employers, it does show that equal pay is still a big thing, and whereas over the years traditionally it's always been perhaps as a public sector issue, local authorities and etc. Actually, it is in the private sector as well, and there is still some way to go, as this case clearly shows. So the key thing to take out of this is, if you are paying a female a lower amount than a male in a similar job, then do make sure, firstly, you have a transparent pay structure, and secondly, that you do have, when you set those differences in pay, clear rationale as to the factors behind that pay. So, for example, if it is a market factor, you know, when you employed the male, it was a much more competitive environment for taking people on, and so therefore you have to pay him more money, then obviously that needs to be documented in evidence, just in case down the line there is an issue. So that was the major case that was reported in January. The second one, again, this will be very relevant when we come on to one of our debate topics later on. Spoiler alert, I'll mention it now, it's to do with vaccinations. This is the one where, I'm not sure, apologies to the gentleman if saying his name wrong, Casamatiana, against the League Against Cruel Sports. Basically, I'll call him Mr. C, so I don't keep butchering his name. Mr. C brought a claim against the League Against Cruel Sports, arguing that ethical veganism can be a protected belief, or a philosophical belief, as it's sort of said in the Equality Act. And that will become, as you'll see later on when we get to chatting about vaccinations, that could be relevant there. So basically, Mr. C said that his beliefs were all encompassing, and basically ethical veganism, in his case, was a protected belief. Now, this was a case at first decision, so it's not necessarily going to be binding law, but essentially the tribunal did find that his veganism was a philosophical belief. Now, the Act basically says, and other case law has built on this, to be a protected philosophical belief under the Equality Act, firstly, it must be genuinely held, okay, which a lot of people would probably be able to argue quite successfully. However, it mustn't be just an opinion or viewpoint. It's got to be a concern of a weighty or substantial aspect of human life, have attained a certain level of cogency, seriousness of importance, and be worthy of respect in a democratic society. So they are the factors that a tribunal will look at when determining whether a belief comes under the Equality Act as a philosophical belief. Now, the judge commented that veganism is not just about choices of diet, but it's about choices relating to what a person wears, what personal care products he or she uses, their hobbies, and the job he or she does. They've in fact chosen to live as far as possible without the use of animal products. The The judge actually quoted that in the judgment when finding for Mr. C. Now, in Mr. C's case, they found that his ethical veganism did have a detailed effect on his day-to-day life. So when he went out for walks, he would avoid accidental crashes with insects or birds when taking the bus or public transport. He doesn't wear any clothes, shoes, hats or fashion accessories that contain animal products. And basically he could demonstrate he really does live by this belief. So the judge found it easy to conclude that there was overwhelming evidence that ethical veganism is capable of being a philosophical belief. Now, as I say, this is the first instance. This was only the employment tribunal. It wasn't the appeal tribunal or court of appeal or anything. So it's not binding. However, I would suspect that it would be likely to be followed in future cases along the same lines. And therefore, on a practical level, it's quite important for employers. Firstly, you need to check your equal opportunity policies and procedures to make it clear. Perhaps you could even comment that ethical veganism can be considered a belief. And you need to ensure that vegans within your workforce are afforded the same protection as employees, say, from particular religious backgrounds. Practical things like in your cafeteria, making sure that you serve food that is has some vegan elements. Secondly, if you're asking people to wear uniforms, make sure that the uniform might sound silly, but the uniform doesn't have anything in it that could be deemed to have been tested on animals. So there are some practical things here that come out of this case. But the definition I gave of philosophical belief will be relevant perhaps when we come on, as I say, later on to looking at the issue of vaccinations at the moment. So on to February. Now, the main case, only one you'll be pleased to know, and then I will be passing over to Chris so he can tell you the next couple of months. This case was all about disciplinary investigation process, and actually is a very key case for yourselves and many of you in HR. Mr. Udin was dismissed for gross misconduct, inappropriate sexual behaviour towards an intern after work drinks. So it's one of these classic social events, but work related, and he was deemed to have inappropriately acted in a sexual way towards an intern, and he was dismissed for gross misconduct. However, after the investigation, but before the disciplinary hearing, the investigating officer learned that the allegation of sexual assault, which had been reported to the police, had been withdrawn. Importantly, the investigating officer did not tell the chair of the disciplinary hearing that this was the case. The dismissing officer, as the chair of the hearing became, obviously couldn't take that into account, and actually did rely as part of the decision making the fact that the complaint had gone on to the police and was a live police matter when deciding to dismiss. So Mr. Udin then obviously brought various complaints, including one of unfair dismissal, in the tribunal. Now, the original tribunal found his dismissal to be fair, but he appealed to the Employment Appeal Tribunal, and they did allow his appeal on the unfair dismissal point, precisely because of what the investigating officer did. So here, as I said, the dismissing officer knew there'd been a police complaint and had attached some weight to that fact in deciding to dismiss Mr. Udin. She actually stated that had she known the withdrawal of complaint when she was given evidence, she would have wanted to understand the reason for it, implying that it may have actually had an effect on her decision. So she'd made a decision on behalf of the employer that was without the benefit of clearly relevant knowledge. And for that reason, the EAT found that Mr. Udin's dismissal was unfair. Now, obviously, the key point from that case is that it is vital for you as the employer to ensure that the chair of a disciplinary hearing has all relevant facts before going on to make a decision. And so this is where investigating managers, officers, whatever you'd like to call them, who carry out the initial investigation, they do need to pass on all relevant evidence, material to the chair of the disciplinary. If they don't, then you may fall foul, as they did here in the Mr. Udin's case, of an unfair dismissal. So that's my case from February. I'm now going to pass over to Chris, and he's going to take you through March and April.
Great, thanks Paul, and good morning everyone, and thanks for joining us. I was obviously thrilled when I was given March as my starting topic, because really there's not much to talk about apart from the thing Paul promised we wouldn't be talking about. There were absolutely no cases that came up that I can tell you about. So this on the slide is really all that happened for the month. We had a pandemic, which is pretty much, as we know, set the tone for the rest of the year. And apart from the introduction of the furlough scheme to try and stop us all panicking about redundancies, and then the amendment to the working time regulations to allow that carry forward of holiday, only where it wasn't reasonably possible for somebody to do so during the pandemic itself, not an awful lot else happened in March, so I can actually cover the entire month in about 30 seconds, you'll be pleased to know. And that's really it for March. It was literally just COVID stuff. April, however, got a little bit more interesting. So first here in April is a bit of a reminder. We know we've talked about this before. We know other people have talked about it to death, and we know people were talking about it for at least 18 months before April 2020. This is when most of the changes under the Good Work Plan came in. The main one that I really want to draw on today that I think we're still seeing issues with is the employment contracts that still don't quite satisfy those updated requirements. I don't know, Paul, if you've seen differently, but in my experience, it's usually the training or probationary period provisions, I think, that tend to be missing more than anything else at the moment.
Yes, yeah.
I mean, the other one, I think, as we've kind of said there, the intention of much of the Good Work Plan really was to help regularise the expectations, the hours of sort of ad hoc and part-time workers. So I think sometimes that's still lacking as well, both in new contracts and in existing ones. It is important. I think this was probably overlooked a little bit by people due to COVID, quite understandably, but it is important that when you're doing those contract reviews or when you're acting for or advising businesses on this, to look back at existing contracts as well. Most of the new provisions in the Good Work Plan took retrospective effect. Okay, moving on from Good Work Plan and on to another case, which actually draws slightly on the last one Paul was talking about, actually. The case of K and L in the EAT. So this case is anonymised for good reason, and it's because it involved a teacher who was dismissed after Scottish police investigated him for inappropriate images of children on a computer at home. Good reason to investigate somebody, you'll agree. He was charged, but the prosecution didn't proceed in this particular case, and the school requested documentation to assist with their internal investigation, again, quite reasonably. As you might expect, because it was a criminal case, the documentation they received from Police Scotland was heavily redacted to the point of being almost useless to them. In the disciplinary, the claimant in this case used exactly the same approach that he had used in the criminal investigation itself. He admitted that the images existed, but denied being responsible for them. His son, I think it was, also lived at the property and had access to the computer. And there was some debate there as to who exactly had downloaded them and accessed this material. What's interesting for us is what happened with the dismissal itself and the subsequent case. So the dismissal outcome concentrated on potential reputational damage. Again, we can see why, given his job, the reputational damage to the school and to the profession of something like this being made public could have been quite considerable. The problem was encountered, though, that the entire disciplinary process itself concentrated on misconduct. Slightly different issue. There's a different, I won't say a different burden, but there's a different approach you take, as I'm sure most of you will be aware, to those two kind of allegations. Initially, the ET rejected the argument that the dismissal must have been unfair because the claimant hadn't had the opportunity to address the real reason that he was dismissed, reputational damage, and had focused all the way through on misconduct. But the EAT disagreed. And what the EAT basically said in its judgment was that an individual needs to have the opportunity to respond to the point that he's actually at risk of being dismissed over. Reputational damage in this case, not the misconduct. So where I think this is going to be important from a practical point of view, from a management of a disciplinary point of view, is to be very, very clear in our minds as early as possible what exactly we're running with. Not to change our minds halfway through, and to ensure that if we want to include reputational damage in particular in these kind of cases, to make it clear from day one before the investigation starts. It didn't actually help the school at the EAT in this case. The reputational damage had been quite heavily referred to even in the investigation report. The fact that it wasn't in that early correspondence, that early documentation with the employee, ultimately caused this to be an unfair dismissal. And funnily enough, I've got through my first 2 months a lot quicker than Paul did, because there was a lot less to talk about for at least one of mine. So I would just check in with Jenny, I think, if she's still with us, and whether we've had anything come up on our sort of first third of the year.
Or if anyone wants,
or if anybody wants to wave at us, yeah.
Yeah, I'm here. No chat messages as yet.
Fantastic.
If anyone wants to ask a question now, unmute themselves, and please do, or you can wait to the end on any of the cases. No.
Let's assume not. Over to you then, Paul.
Okay, thanks. Well, it flips now, because I think you'll see in a minute. It's the other way around. Mine's a short section here, but that's June. I'll come on to that in a minute. So thanks, Chris. So on to May. One main case in May, and this was actually to do with TUPE, so apologies if many of you have not had much involvement in TUPE, but it is a very important case, because actually the government gave guidance which was incorrect around this, and as this case confirmed. I'll come on to that. So it's the case of Ferguson and others with Austria Asset Management Limited. Now, as I say, it was a TUPE situation. Mr. Ferguson and 3 senior colleagues, directors of a property management firm, were basically selling the business. And it had a substantial portfolio in Mayfair, so quite a lucrative business. In September 2016, the notice was given to terminate the employees of the company's management agreement, and AAM, so Austria Asset Management, took over the portfolio. So there was a TUPE transfer, because there was a change of a service provision from their company over to AAM. Now, obviously, Mr. Ferguson and his colleagues knew this was happening, and quite sneakily, or you could think cleverly, they, July 2017, before it happened at the end of September that year, he and his director friends varied their contracts considerably, giving them new rights. So this was to guarantee bonuses of 50% of salary, new entitlement to termination payments of a month's salary for each year they worked, and an enhanced notice periods as well. Now, of course, they did this before the transfer, and then gleefully handed over these varied contracts to AAM as part of the employee liability information. So as many of you will know, as part of a TUPE process, the transferor, so the outgoing, in the service provision change, the outgoing company has to provide information about their employees to the transferee, the incoming one. And of course, they gave these varied contracts with all these new lovely rights. Now, the transfer then went ahead, and not surprisingly, AAM then dismissed all 4 of them very soon afterwards for gross misconduct. They brought various tribunal claims, including payments for those enhancements that they put into the contract. Now, there was various decisions made by the tribunal, but essentially the key one for this case that we're looking at is those contractual changes. Were they valid? because AAM was saying, well, it's a TUPE transfer, any variation in terms and conditions are void. So this is completely the opposite to the normal way, whereby after a TUPE transfer, the incoming transferee tries to vary the terms, and it's the employees that complain, well, you can't do that because it's void. This is the other way round. It was the actual employer saying they're void because they've been made more advantageous. And the tribunal held that they weren't valid because any change, for those of you who really want to look into it, that's Regulation 4.4 of the regulations. That makes all changes void. Now, as I said, the government had actually given incorrect guidance before, saying that it was only detrimental changes that would be void. The 4 gentlemen appealed, and it went to the AT, and the AT agreed with the tribunal, and their appeal was dismissed. So this case basically makes it clear that any contractual change, not just adverse ones, it can be advantageous ones, are void. Now, you could say there was a bit of a policy decision here. I'm guessing the tribunal and the EAT probably didn't like Mr. Ferguson and their colleagues for what they would have seen as being a bit of a sneaky trick. But nevertheless, the law backs them up, because the interpretation that any contractual change is void is consistent with the original Acquired Rights Directive within Europe, which of course we were part of when the TUPE regulations were founded. It's also, though, even though we've got Brexit now, consistent with UK case law as well. So it's not like coming out of Europe changes anything. And basically, our thought, it's a common sense approach, and it also removes the possibility of arguments. Oh, is a change detrimental? Is it advantageous? As well as I say, a policy change as well. Oh, we've got a question come up from Jane. Any changes void within a period of time? It's a common question, Jane. That technically there is no time limit. So within the legislation, within case, there is no set time. However, as time goes on practically, there's more scope for the employer to argue that the change is not to do with the transfer, but to do with other factors. So in reality, the longer the period of time after the transfer, the more likely you're going to be able to argue that the change is not because of the transfer and therefore isn't void. But there is no set sort of magic 18 months, 2 years, anything like that. It is a case-by-case basis, unfortunately. In practice, you've got to show that any change is not because of the transfer; it's for some other reason. That's May. I think that was the main case in May. June, as I said, is going to be very quick. It's a bit like Chris's March one. There was no major cases, again, in line with the fact that everything was changing around furlough. As you may remember, we were coming out of the lockdown by then, but furlough scheme 2 was announced. At the time, there was going to be a wind down because we'd come out of lockdown, and everyone was hoping it was going to be a more rosy future than it actually turned out to be. And but importantly, flexible furlough came in July, and it was announced in June, and that was actually quite important. Many employers used that, as did Fretton's, and Chris himself used it, didn't you, Chris?
You did, I did.
Or rather, Fretton's used it on behalf of Chris. So yeah, that was an important change as far as furlough in June, but there was no real big cases that month. So I'm going to hand back to Chris now for July.
Thank you. And yeah, there might not have been in June, but there was quite a big important case in July. Robinson and DWP is one of those cases that has been floating around for quite a long time now. As we can see, it reached the Court of Appeal eventually, so it had already been through the tribunal and the EAT. The claimant in this case was an administrator for the DWP. She suffered from a medical condition which left her partially sighted in her left eye. And what this meant basically for her was that she struggled to see the computer system DWP was using. Now, you might expect this would have been relatively easily resolved, but no, as per usual in these cases, we went through sort of the rigmarole of attempts to help her, alternative paper-based roles being offered. I think in one case, they even managed to change the computer system so that it got worse for her. Sickness absence, there was a grievance, and ultimately she brings claims for Section 15 Equality Act, something arising from a disability, and Sections 20, 21, the duty and failure to make reasonable adjustments. At the first instance, the tribunal actually rejected the Section 20 arguments entirely. DWP had sought to make improvements. They'd offered her an alternative but comparable work, paper-based, so that she didn't have to look at the screen, didn't have to try and use the system. But they also upheld the Section 15 argument. And it was actually a strangely argued Section 15 case, because what it was based on was the way the grievance itself had been handled and the way DWP had handled its internal procedures and processes in dealing with the issues that Ms. Robinson was raising. Yes, it had been a very protracted process. There's no question about that. It had taken a long time to achieve anything. The grievance never really got anywhere, hence the claims. And what the ET sort of said, quite badly, I think, in the judgment, was that DWP had failed to accommodate the disability through the grievance process, and that any resulting stress and anxiety had been apportionable to that. Quite expectedly, the DWP appealed, quite rightly they appealed, and the EAT overturned that Section 15 finding. And so the claimant, as we can see, then appealed to the Court of Appeal, who also agreed with the EAT, and provided us some useful clarity on the different standard in a Section 15 claim. This is nothing new, but it is helpful that it's come from the Court of Appeal. So what we're looking at, and the difference between a Section 15 claim and other kind of disability claims brought by claimants, is that we don't have what we call a but-for test in Section 15. So the claimant isn't arguing that the treatment would have been fine if they weren't disabled. They should be arguing that they have suffered a detriment because of something which comes as a result of their disability. So classic examples are where people have a side effect of a medication they're taking, and they're sanctioned for that. Somebody who is diabetic being sanctioned for timekeeping because they need to use the toilet more regularly. Those are the kind of things you're usually looking for in Section 15 claims. The stress that had been caused by DWP's internal processes had no causal link to the claimant's disability, the partial sightedness. There's no correlation there, you can't link them. And so having a poor process for dealing with raising a direct or a reasonable adjustments claim doesn't automatically give you a Section 15, is what the Court of Appeal was saying here. So while that's sort of interesting from a legal point of view, I suppose the question is, what's the practical effect of this case? And actually the practical effect is nothing to do with Section 15, in my opinion. The practical effect of this case is actually the amount of time that the tribunal, the appeal tribunal, and the Court of Appeal all put into looking at the decision-making processes throughout. So in the first instance, this was the reasonable adjustments case, and then all of the decisions that were taken in terms of this protracted process. While the employer won in this case, I think the important thing to take away from it is that no matter who is making that decision, no matter whether it's a grievance outcome, a disciplinary outcome, or simply the decision to pause some kind of informal process, that decision can always be subject to the court's scrutiny. Okay, so it's not just the case that, you know, if you make a decision about a grievance and it's not upheld, it's maybe not just that decision maker who could be subject to the court's investigation. It could be anybody who's had a hand in the process whatsoever. It's also important to bear in mind, going right back to the reasonable adjustments issue in this case, that a lack of consideration can be subject to scrutiny just as much as the things that are considered. You may well be asked a question in tribunal, why didn't you think about? Or more likely, under cross-examination, you didn't think about example, did you? And if you're stuck saying no in that situation, you've got a problem. So that's kind of the main thing coming out of July. Yes, the interesting thing between disability and something arising in consequence of a disability is interesting, but as I say, the practical effect of the case is to take from it that every decision is subject to scrutiny, not just kind of the major one at the end. Moving forward into August then, and this brings us back to employment status, because don't we all love an employment status case? We know that these are all over the place: Uber, Deliveroo, and the third time, I believe, City Sprint and their cycle couriers. So obviously the primary issue, as we know with these cases, usually is the degree of control employed by what I will call the engaging party over the individual. We've seen this decided on things like being required to wear a uniform, fixed working hours, being subject to grievance or disciplinary procedures, and most commonly at the moment, this issue of substitution, the idea that somebody is entitled to send somebody else to do the job for them under the contract. The employer, in quotes, might well reserve the right to reject that substitute, but obviously the idea is that they can't then drag the principal in and say, you've got to do the job because you're contracted to do it. The idea is ultimately that there is no personal obligation on the individual to do that piece of work. So as I say, this was the third case to go against City Sprint on basically the same issue. They'd already in the past had contracts referred to by employment judges as indecipherable, and this one failed, as we say again, on personal service. What came out of this was that the right of substitution was basically deemed theoretical and had never been exercised. Personal performance of the obligations under the contract was necessary, and none of the claimants had ever used a substitute. It was accepted that the claimants had flexibility as to their working patterns. They could choose their hours on a day-to-day basis, but once they'd indicated that they were willing to start work, they then had to keep accepting instructions and personally perform those until the end of the day, which almost entirely defeated any self-employment argument as far as I'm concerned on that basis alone. The cycle couriers didn't provide their services to anybody else. They didn't market them to anybody else. And so obviously they were certainly deemed to not be self-employed in this case. Ultimately, as is always the case in employment status questions, it's about what's happening on the ground. It's all fine and good, the contract saying you might have a right of substitution, but if that is not going to be exercised, couldn't be exercised, and would be refused, it's not a clause that's going to protect the business in these kind of situations. It is worth pointing out, though, the reverse is equally true. Just because a clause isn't exercised doesn't mean the entitlement isn't there. What a claimant is going to have to show in these kind of cases is that it couldn't practically have been exercised or would have been refused by the employer. So this isn't one of those cases where it's going to be an absolute black and white. If it's in there, yes. If it isn't, no. And it's not even if it's exercised or not. It's always going to be a question of what would have happened, just as these employment status cases often are. I think from a practical point of view, it's a combination of careful drafting and B, making sure that sort of any right that is put into a contract to indicate self-employment status is actually in reality what happens. The moment I think a business starts to impose a significant degree of control, particularly over things like working hours, practices and procedures, you're looking much more likely to be a worker than you are a self-employed contractor. And again, that's pretty much it from the summer. We were waiting for the courts to catch up a little bit after lockdown, so we only had sort of these one or two cases. I'll just check in with Jenny again, I think, since I'm at the end of my bit.
Yeah, no more messages.
Oh,
That's a shame.
Sorry. Yeah, no, there's no more messages
Okay.
through.
Cool. Okay, thanks then. In that case, I'll finish there and let Paul lead us into the end of the year.
Yes. Thanks, Chris. So September, please. Right. Okay. So September, a couple of key cases. The first one is actually a Scottish case, but it is interesting and actually relevant to the rest of the UK as well, because it's all around social media. Massive thing. We get lots of queries over social media both from employers finding that their staff have put something on social media that brings them into disrepute, or they at least claim it does, and similarly from individuals who are worried that they've put something on there as well. This was slightly more of a twist on the social media though. This was to do with whether WhatsApp messages that were sent between police officers could be used as evidence in the case against them. So basically, the Police Service of Scotland, it was held in this case, were permitted to use the content of the officers' WhatsApp messages during misconduct proceedings, even though they were deemed, the officers argued that they were private chat groups. So basically, these 10 officers, as it were, who worked for the Police Service of Scotland, were sending inappropriate and offensive messages to each other that were deemed to be sexist, racist, and homophobic in their nature. Now, they did this despite fully knowing that obviously as police officers, they had to adhere to professional standards. You could argue we should all be doing that anyway, but certainly as police officers, they were deemed to do that, and that was to apply at all times, and they had to act with honesty and integrity. Okay, so what happened was basically these messages were discovered on actually a suspect's phone during an investigation in 2016 into sexual offences within the police service itself. So their professional standards department then subsequently brought misconduct charges against the officers involved when they investigated further and found that these messages had been going to and from, as I say, between 10 officers. Now, the officers then tried a petition to the Court of Session, as it is known in Scotland, basically trying to argue that it was a breach of their privacy, and therefore the WhatsApp messages shouldn't be taken into account during the proceedings. They argue basically they had a reasonable expectation of privacy when they were sending those messages. Not surprisingly, I would say, it was found that there was a professional obligation on them not only to report improper conduct, but obviously to disclose them if they knew that they were taking place, and that therefore the officers had no reasonable expectation of privacy with those messages, and they could continue to be used. So the officers appealed. So in Scotland, it's from the outer house to the inner house of the Court of Sessions, it's known. But their appeal was dismissed again for pretty much the same reasons, that the professional obligations and the legal obligations, as we've got on the slide here, in this case, outweighed their right to privacy under Article 8 of the European Convention on Human Rights, which is what the police officers have tried to use to get the messages inadmissible. So whilst this is a Scottish case, and obviously there were a number of factors in the case that are only relevant to police officers, it does demonstrate on a practical level to us that the law around social media and employers using it in misconduct cases is continually evolving, and that if you can show that there are obligations on individuals that outweigh the right to privacy, you may be able to use messages that could in the past been deemed to be private. I think we just had a question come up. Personal devices or police devices. Chris, do you know? I'm not sure. Obviously, it was their personal, as in their phones they used, but I don't know if the police service gave them the phones. Do you know?
I believe they were personal devices.
I thought they were just personal, yeah, but
because I imagine as the police service would have retained the right to search their own devices anyway.
Yeah, I thought they were personal. I hadn't seen anything in the case where it mentioned that like we are at a certain level, we are provided personal phones paid for by the employer. But no, personal devices were being used. But even then, so you would think personal device, private chat group, you would think they could have a reasonable expectation of privacy. Not so in this case, and there could well be other cases in the future going forward. As I say, even though it's a Scottish case, it's certainly persuasive on all courts across the UK if it comes up again. So it's something to consider. What Chris and I would certainly suggest is, if you ever did have this situation whereby you stumbled across messages or it is reported by someone, then it's probably worth either taking advice or at least seriously considering before using those messages. But it may be possible that even if they're on a personal device and in a private group, you would be able to use those messages in certain circumstances. The second case in September that was of importance, that went to the EAT, was the case of Sullivan and Berry Street Capital Limited. Now, this was all to do with mental health and disability, and it's actually in some ways quite a surprising case as we go through. Mr. Sullivan works as a sales executive for a small finance company, Berry Street Capital. Now, he had a relationship with a Ukrainian woman, and shortly thereafter, he began suffering paranoid delusions that a group of Russian gangsters were out to get him. Okay, but they were quite serious delusions. They began around May 2013, and the CEO of the company became aware of them a few months later. Now, the way these delusions manifested with Mr. Sullivan, it caused difficulty in sleeping and ultimately affected his attendance and behaviour at work, which became extremely erratic. Having said that, his performance hadn't been good before these delusions started. However, matters did improve for him after September 2013, and in early 2014, Mr. Sullivan saw a doctor and psychologist, and they agreed that there was an overall improvement in his situation. So much so that by September 2014, when a new colleague joined the company and worked very closely alongside Mr. Sullivan, when it later came to the case and he gave evidence, he said he'd noticed no change in Mr. Sullivan's behaviour during this time and was certainly not aware of any mental health issues. Now, between July 2014 and September 2017, Mr. Sullivan had continued performance reviews. His timekeeping and attitude to work remained poor despite the apparent lack of a mental health issue. And in September 2017, he was ultimately dismissed for poor performance. Now, Mr. Sullivan brought disability discrimination claims, saying that obviously he'd been discriminated against because he was disabled because of the delusion that he'd suffered as a result of a mental health condition. Now, it was accepted both, I believe, by the company, but more importantly by the tribunal, that he did have a mental health impairment at certain times, namely around May to September 2013, when the delusions did have a substantial adverse impact on his day-to-day activities. However, they found that there was no substantial adverse impact or effect in the intervening period after that, before he was dismissed. Okay, and more importantly, because it didn't last at least 12 months, which is one of the definitions of disability under the Equality Act, in essence, he wasn't disabled at the relevant time, and therefore his case failed on the disability discrimination. He didn't even get over the first hurdle. He didn't show he was disabled at the material time, which you may think is surprising, but nevertheless, that's what the original tribunal found. Now, of course, Mr. Sullivan didn't like that, and he appealed, focusing on two aspects of the tribunal's decision, namely that the substantial adverse impact didn't last throughout the time, as they found, and also they said it wasn't likely to reoccur. Now, his appeal was dismissed by the EAT. They basically said that despite the evidence of the doctor and psychologists, the tribunal were entitled to rely on the evidence of Mr. Sullivan's colleagues. So they actually preferred the evidence of his work colleagues over the medical professionals. So that's quite an interesting element of the case itself. And therefore that his any effect on him was not substantially adversely affecting him between September 2013 and 2017 when he was dismissed. Having said that, there was a twist to this, because his delusions did reoccur in 2017, right just before he was dismissed. And therefore he argued, well, they were obviously likely to reoccur because they did. That was basically his common sense argument, you would think. Oh no, said the EAT, that doesn't count. It's at the time of the original decision, namely back in 2013, was it likely to reoccur? And again, they preferred the evidence of the colleagues over the medical professionals in saying that at that time, the employer was reasonable in deciding that it wasn't likely to reoccur. And now I'm not sure, obviously we weren't in the tribunal, we weren't at the EAT. Maybe Mr. Sullivan wasn't a very likable person. I don't want to, who knows, we weren't there. But in some ways, this is a surprising result, I would say. But it does practically demonstrate that actually there's quite a higher hurdle than perhaps some have previously thought in establishing what disability is under the Equality Act. It is clear, as I say, we don't know if he was liked or not, but he was certainly deemed not to be a credible witness during the tribunal. That does come out in the judgment. And as I said, both Mr. Sullivan's evidence and that of his medical advisors was rejected in preference of those of his colleagues. The tribunal and the EAT both found them much more persuasive and credible. So I must admit, when we're getting quite a few disability discrimination cases at the moment, and there are some employers will often think, oh yeah, they're disabled because they know of a medical condition, tick, we won't even think about that. It is something, and certainly Chris and I would always look at it, always look to see whether they are actually disabled under the Equality Act, because sometimes there are arguments to show that that you can use that they aren't. Oh, sorry, someone's just asked, what was the name of the legislation again that encompasses Article 8, please? I think it was the European Convention on Human Rights, was the piece, which many people, Article 8 is all about the right to privacy, and that's what everyone uses when they use privacy arguments. So it's European Convention on Human Rights. Okay. I think that's it for September. October, please. Yep. Now, again, this was a quiet month for notices. Always seems to follow, you'll notice, there was a pattern during the year when I think what's happening with furlough, the courts seem to go quiet. The main thing, the two things in here, it says on the slide, obviously rates have gone up again with COVID, and the furlough scheme was in fact extended. The main important difference at the end of October, which is right through now until the end of April, is the major change. If people are on notice now, you cannot claim for them under the CJRS, which I've had that be a real effect on some clients locally in retail who obviously needing to make people redundant, and as soon as they're putting them on notice of redundancy, they then can't claim for furlough. So that's an important thing to consider. But that was really the only change to the furlough scheme, which, as you probably all know, is currently going through until the end of April 2021. The other thing I won't spend much time on, if any of you in the public sector want to ask any questions on it later, please do, but restriction of public sector exit payment regulations, just setting caps on how much someone could be paid normally under a settlement agreement, but nevertheless when they are exited from their employment. And now to do the final couple of months, I'll pass back to Chris.
Yep, great, thanks Paul. And yes, October was my revenge for giving me March. Okay, end of the year then, and we actually started to get a flurry of cases kind of following that pattern that Paul was talking about. We had nothing happened while furlough crops up, and then suddenly we have two fairly significant Court of Appeal cases in November. So Heskett is there as a reminder of the so-called costs plus rule and how that works in defending indirect discrimination claims. Obviously, remembering that indirect discrimination can be justified if a business is taking proportionate steps in achieving a legitimate aim. In the case of Heskett, what happened here was a change in pay structure, so that progression up the pay scale took longer than it had done previously and was therefore said to be disadvantageous to younger staff. In fact, it actually took around 3 times as long to make the progression in some of the examples given. And we're not just talking 6 to 18 months. If I remember rightly, one example they gave was that it would take 21 years rather than 7. So we're talking quite a substantial financial disadvantage over the course of somebody's career. There's no question the policy was indirectly discriminatory. It certainly affected younger staff worse than it had done staff who'd been there longer already, but was ultimately justified somewhat unusually on what were basically financial justifications. So it's long been held in indirect discrimination cases that pure financial cost alone, doesn't justify discrimination. And it's always been said that there should be cost plus something else. That plus has always been a little bit vague. It's not always needed to be anything substantial or significant. It's just enough that the discriminatory policy isn't on pure financial basis. And what the Court of Appeal said in this case was that if you ignore the real life constraints, the actual business circumstances in which an employer is operating, what you end up doing is creating an artificial bar that you're measuring that employer against. Businesses operate in the real world. They don't operate in some fantasy sphere where money doesn't matter. And what the Court of Appeal said in their judgment was that that's never a good thing when determining that living within an employer's means is problematic. You can't say that. An employer has to be able to operate within its own economic constraints. And that is distinguishable solely from having a policy of trying to save cost. So what the case of Heskett actually does is reassert this costs plus rule that already existed, but to my mind, perhaps slightly widens the plus bit a little, with an important distinction between wanting to do something just to save money or to make sure that the directors are still paid as much as they already are, and operating within the employer's means. What the case basically says and kind of reasserts is that you could find justification for an indirectly discriminatory policy that arises from the business's need to survive financially. And I think in the current climate, that is something that could start to crop up increasingly for certain sectors. It will mean obviously being very, very careful before putting a discriminatory policy in place, as always, particularly making sure that it's only indirectly discriminatory. You absolutely can't have a policy that is directly discriminatory that is going to be justified in any way, shape or form. That can't happen. Moving on then, the Simpson case, again, it kind of reconfirms things we already know about whistleblowing and protected disclosures. And what this case did really was just the Court of Appeal confirming for us again what is and is not a protected disclosure. What happened in this case was sort of that classic situation where at the end of a grievance, you get about 20 bullet points all with things the company does wrong. Designed to panic you into thinking that somebody's making protected disclosures. And what had happened in this case was the claimant had made about 37 general bits of criticism that he contended amounted to protected disclosures. Every court, the tribunal, the EAT and the Court of Appeal disagreed with him entirely. And the Court of Appeal just helpfully confirmed to us that, okay, there's no hard boundary between disclosing information and making allegations, but context will always be important. The classic example that's been given in previous case law is all to do with general comments about health and safety, as opposed to making them in the context of actually pointing at the health and safety breach while saying it. So yeah, I mean, there's really not much to say on this. It is just an important update. And I think from a practical point of view, not to necessarily panic if you do get that grievance that's got a load of general comments in the back, and just be satisfied that they are or are not protected disclosures before proceeding. Quite often, I think in our experience, they're not. General whinging usually isn't. And that was pretty much it for November. So just taking us right into the end of the year. And this was a pretty well publicised case when it was announced the outcome in December, Taylor and Jaguar Land Rover. So this is one of those first instance employment tribunal cases, not unlike Paul's Mr. C earlier, which doesn't necessarily define the law, but probably defines the direction the law will head in. It dealt with the issue of transgender rights and whether an individual taking steps to identify as a gender other than the one associated with their birth sex is protected under the Equality Act, and the importance in that distinction between gender as what I think we can start to consider a social construct, and sex being, for legal purposes, the biological designation. So Ms. Taylor worked for Jaguar Land Rover for some 20 years, presenting outwardly as male. She began to identify as gender fluid or non-binary from about 2017. So while a man at birth and biologically, she didn't identify as male. On some days she wore clothing associated with being female, and as is clear from sort of my introduction so far, was being addressed by sort of traditionally female pronouns. In subsequent years, from 2017 through to about 2019, she began to be more active in Jaguar Land Rover's LGBT network. And as she became more open about her gender identity, the abuse started, and it was some pretty horrific abuse from colleagues. She was referred to as it by management because nobody decided which pronoun they should use, despite her saying that she wanted to use female pronouns. Had absolutely no support in addressing this from Jaguar Land Rover's HR team, to the extent that in its judgment, the tribunal determined that the response by HR to these complaints of abuse and bullying was so poor that they successfully found an example of a harsher response from HR being given to all of the staff in response to alleged breaches of the company's gifts and hospitality policy. They took that more seriously than they did the abuse over gender identity. The claim was brought to the tribunal then on various grounds, and it does test the water. It is very much a test case as to how gender identity fits in the Equality Act. If we think about the protected characteristics, it doesn't sit within sexual orientation because it's not about who the individual is attracted to. And the definition of sex for the Equality Act doesn't really help us because that's an absolute biological definition. So the only one where the ET could recognise a claim being possible for gender complex identity issues was under Section 7, and that is Section 7 there on the slide, with my emphasis on the words "a process" because that's what the tribunal focused on. The tribunal decided that a process proposing to undergo, is undergoing, or has undergone a process can be read quite broadly. And whereas even 6 months before this case, most employment lawyers would have said to you that requires some kind of medical process, whether that's surgical or HRT. What this case does is shows that no, it doesn't need to be that far at all. Somebody self-identifying their gender is going through a process of reassigning that person's sex. So I think, yeah, okay, it's a first instance tribunal case. It could be deemed differently by a different judge on a different day. It could be overturned on appeal. I think that is highly unlikely. I certainly haven't seen any criticism in legal circles of this widening of Section 7. And I think it's probably the direction that we need to accept that Section 7 is going to take, probably quite rightly. I think from a practical point of view, obviously what this means is that complex gender identity issues are increasingly going to come to the forefront. We're already seeing it in the media more and more. We're already seeing it as an issue in the public sector. And as people will be aware from reading the media, gender identity issues, as these things often do, start out in schools and then tend to spread outwards. For the purposes of the workplace, practical issues, assume somebody who is self-identifying their gender is protected under the Equality Act. You know, that is going to mean protection from abuse by colleagues, from policies in place that may be directly or indirectly discriminatory. On a practical issue, don't be the HR team that Jaguar Land Rover was. Do the training on complex gender identity issues. There's plenty out there, and if this is an area of interest, it is something I'm sure we can do more on in the future. Practical implications, obviously, again, we've seen this in schools, we've seen it in the public sector. The big one is going to be toilets and changing rooms. Best thing you can do, I would suggest, as in any case where you're talking about a minority group, check what they want first and use that as your basis. Obviously, that is particularly important when you're talking about somebody who is self-identifying by gender, pronouns, how you address them in writing. You know, until recently, somebody might have got offended if you got the form of address wrong. Now they could have a discrimination claim. The final one, and it's an interesting area because case law is still conflicting, and it will probably be decided on an employment case, as these things usually are at some point in the future, the conflict with religious belief and people in your workplace who might not believe in self-identifying gender. That is going to crop up at some point. It hasn't yet as a direct case where these two rights are directly conflicting for the purposes of the case itself. But at the moment, there is conflicting case law. We've had one person in tribunal who was fairly dismissed for anti-transgender posting on social media, but conflictingly, we've had the High Court tell us that there's no point having free speech if you only protect inoffensive speech. So you know, there's no point trying to decide at the moment which way a case would go on that. So my advice on a practical basis would be to be careful, balance where you can, but yes, assume that somebody who is identifying as non-binary or gender fluid is going to be protected moving forward. That's the big case from December and brings us to the end of the year. I think what I'll just do, just to finish my bit off, a couple of amusing entries, just of cases that didn't really fit anywhere else, just for a bit of amusement, really. That first one there involving Eurasian Natural Resources Corporation. It was a really complex case in the civil courts involving legal privilege, intellectual property, and protection from harassment rather than Equality Act. And in this case, what was happening? The company was spying on their in-house lawyer. Never a good idea to spy on your employees, as I'm sure you already know. Much worse if you get caught, and even worse if that person is your in-house commercial litigator. The sub-bullet point there is the genuine defence that the company tried to run with. They tried to argue it can't be harassment if we didn't expect him to find out that we were doing these things. Funnily enough, the judge disagreed. Certainly for protection from harassment claims, I absolutely agree that it would also apply to Equality Act claims. The moment somebody finds out that there's conduct going on that they don't want happening, it becomes harassment. You're not going to get away with it by saying we were abusing this person behind their back and hopes they wouldn't find out. The second one there, Will Noland, people may be more familiar with him. This is the Eton schoolmaster who was dismissed last year, actually going back to what I was just talking about because of his controversial gender identity views that he posted online. He made an attempt, his and his supporters, for a personal act of parliament requiring his reinstatement. Legally, it's possible. I can't imagine for a second that our parliament would have time to pass the Reinstate Mr. Noland Act. Yeah, so they're my two amusing ones. Good luck if you encounter either of those in a claimant in the future. More than happy to act for you. Paul, I'll leave you to deal with some of the definites of 2021.
Yeah, would you go on to the next slide? Have we got?
Yes, rate change. Yeah.
I was going to say definites. Very quick, and some of them haven't even been announced yet. So. We always, in the February one, normally give the update on the statutory rate changes that are coming up in April. 12th of April this year, it's actually slightly later than the financial year end or start of the new year. As is often the case, the unfair dismissal compensation cap and the limit on a week's pay for redundancy, which as you can see, the current limits there, the one we use all the time at the moment is obviously the £538 per week when calculating redundancy. They're to be confirmed. They're not normally announced until the spring budget, so we are still waiting on those. I would suspect they won't go up much at all. I think they are based on the earnings index, and I don't think that's going to be very high this year. Which is borne out by the ones that we do know. So as you can see, statutory sick pay has only gone up 50p at the moment. We've put watch this space, but we will have to wait and see. But certainly a very low increase at the moment. Similarly, the maternity, paternity and other sort of family-friendly rates are up to £151.97, so only a 77 pence increase. So again, very small. And the earnings limit is at now £120 a week, with the upper one at 962. So the thing to take from this, and I think the dismissal compensation and the redundancy pay amounts, they're very small increases this year. Okay, but as soon as we do know the ones that to be confirmed, then we will obviously publish those. Okay. That's it, Chris. I'm not, because I'm conscious of the time and we've still got a couple of important things to talk about. Well, IR35 again, very quickly. I could go into loads and loads on this. It was meant to happen last April because of the pandemic and everything. It was delayed to April 2021. The changes were already imposed on the public sector, and basically this change is now moving it into the private sector as well. And basically the changes mean that medium and large businesses will be responsible for working out a contractor's employment status, not the contractor. So you, as the engaging party, as Chris nicely said earlier, will be on the hook if there's any employment status dispute. Contractors should, more importantly, be given the reasons behind the decision, and they can dispute it if they disagree with it. Now, as I say, this is medium and large businesses. Small businesses are continuing to be exempt for now. So if the contractor works for a small client, the contractor will still be responsible for working out their employment status. Now, you may want to know, if you haven't looked already, what is the definition of a small business? They have to meet 2 of 3 criteria. 1, annual turnover of no more than 10.2 million, a balance sheet total of no more than 5.1 million, or no more than 50 employees. So you have to tick 2 of those 3. If you can, you are a small business and you do not come under the IR35 changes. If any of you got any issues with that, then we can obviously cover that later. But that's just a reminder. That was meant, we did cover it before because it was meant to come in last April, so it's been delayed to this April. So now on to some thing, and this is where we will hopefully open up for questions and debate as well. But over to Chris.
Yeah, I suppose, as Paul says, this is one that we can maybe open up a little bit more, maybe change away from presentation to at least us discussing. Probably tick off 1, 2 and 4 of those fairly quickly. Brexit, yeah, we'd all speculated on what changes might come in after Brexit to do with employment law. The short answer at the moment is pretty much nothing. The consultation on changing employee rights was brought to an end by the government a couple of weeks back. Realistically, from my point of view, I don't think we're going to see anything, certainly not this side of the summer, probably not until the Parliament beyond that even, I would have thought. Point 2 on there, yeah, just a reminder on the changes of the immigration rules. Again, it's sort of Brexit related. Don't forget, transition period has ended, so you're needing to bear these in mind when recruiting. EU, EEA and Swiss nationals still have rights under the settlement scheme until the end of June, but people you are bringing in now, no matter where from, are going to require a visa under the new UK points system. Fairly niche area, overlaps with immigration law. If people have got particular questions, I think we probably deal with them individually rather than as part of this discussion, because it will be individual dependent. I'll skip point 3 just for now and just briefly cover this redundancy protection for pregnant employees. Still technically in consultation stage. The government is basically intending to extend the protection cover for pregnant employees. And this is in relation to the right to be offered any suitable alternative vacancy. At the moment, the proposals are to ensure that that comes into effect from the point when the employee informs the employer that she is pregnant, to extend the protection to 6 months after the mother has returned from work, with the protection period starting when maternity leave is finished, and to mirror the extension of the redundancy protection for people taking adoption and shared parental leave as well. Those are the current proposals. Keep an eye on them once we know what's going on. We will obviously update if the law changes. Just on that last point, yes, adoption leave and shared parental leave, but not paternity leave, interestingly. And I suppose really that brings us back to point 3, which is what we said right at the start. We wouldn't talk about too much, but only where it's sort of relevant and there are new issues coming up. The end of furlough, yeah, it's going to end at some point. They can't keep rolling it out forever. The economy can't sustain that, no matter how bad sort of these new variants of the virus gets. So yeah, this is almost certainly going to lead to redundancies at some point in the near future, and it's us who are going to be dealing with those. All the usual stuff on redundancies, I won't go into any detail. Hard time for everybody. Reinforce that to both sides if you're stuck in the middle because you've been brought in to deal with it. Nobody wants to be making them. It's tough for employees and employers at the moment. But what I will say, in certainly my experience over the last few weeks, individuals will claim if they think there's a chance. It's totally worth them doing it at the moment because they're not going to be walking into an alternative job. So I've seen quite a few inquiries myself, Paul, I'm sure you have as well, just people phoning up to query the redundancy process they've been put through to see if we can identify even one point that might make it unfair. And if we can find one and they want us to, we'll run with it, is the honest answer. Anything that could give a sympathetic judge the chance to go, yep, that looks a bit unfair to me, and I think you'll find people run with it. So my advice at the moment, follow procedures even more rigidly than people normally would. Have a procedure in place, even if it's only one person with no pull. Just do absolutely everything you can to make sure that employee knows what's going on and has had the opportunity to give their input to the process, I think.
Chris, sorry to interrupt. There's a question on the
Sure.
immigration. So do you want to cover that?
Yeah, I can't see it because I have my screen set up.
Right. Okay. I'll read it out to you then, because
Thanks.
I'll let you do. So I answered the other ones. I'll let you answer. Rules. If there are work placements unpaid who arrived in June 2020 and due to go home in June 2021, is it okay, or do you have to apply for visa sponsorship? So if they're going home, basically unpaid work placements going home June this year.
Short answer, I think I'd have to check the immigration rule unless you know that one, because I can't immediately think of the answer.
Yeah.
No, I'll be honest, I'm not sure. So I'm happy to follow that up afterwards.
Okay.
I think that's an immigration.
I thought that might be a question. Someone's actually asked. Yeah, Paul, do you want to unmute yourself, Paula?
Is that all right? Sorry, I was just being a little bit lazy.
We don't want it just to be our voice.
So basically, at the moment, we've got an employee that has they've secured themselves a 3-month placement in Poland, and so they work in one of our shops. Now they're saying that they want to receive furlough pay from us, but they're not even in the UK. And for me, I don't think it fits. I don't know. I just wanted to get your thoughts. We've said no to furlough pay, but they think that we're being unreasonable. Because I think for me, my reasoning with why it doesn't feel right is when the shop reopens, they're not going to be here to come back to work.
Yeah, morally, yeah, it doesn't. Ultimately, it's your decision whether you offer furlough. I'm with you. Even though technically they can, then doesn't mean that you should agree to it. And yeah, that doesn't.
And they're not really that forthcoming with any kind of like information, because we were sort of like, you know, what are you going to do if we reopen, say, for order and collect in March? Are you going to be able to come back to work? And they were just kind of like, well, my flight's booked for next week, and there wasn't really much other like information from that. But I mean, if you're flying out there and you've secured a 3-month placement, you're not really going to be rushing back, are you?
No, I mean, it sounds to me like we've had a lot about this sort of viable job, haven't we, come up more recently as well. It just sounds like it's not in the spirit of the scheme to me anymore.
Yeah, okay.
Technically, you could. There's not that was answered quite early on. That, you know, if someone goes overseas, can you still claim for furlough? The answer is well, yes, but it's not. I agree with Chris. It's not.
Yeah, and there's certainly no obligation to furlough. Isn't a reasonable alternative to redundancy. It's not a reasonable alternative to anything else. It's entirely optional.
Okay, lovely. Thank you.
Okay. So I think, as I say, that kind of brings us on to what's left there with the end of furlough and what kind of COVID is looking like for us moving forward, which is A, the question of long COVID, and B, the question of vaccinations. Paul, do you want to start with vaccines?
Yeah, this has been a hot topic literally in the last couple of weeks. So, and there has been, some of you may have heard, there's been clips, there's been segments on radio, there's been stuff online, all about vaccinations and employers, firstly, wanting to mandatorily vaccinate their staff, particularly in certain sectors and the social care sector, etc., and whether they can do that. Now, the first thing to say is you obviously, as an employer, shouldn't, and under law cannot force someone to have a vaccination. That would actually be an injury to them and possibly an assault, and all of, you could even face criminal charges. So you can't force someone, which I'm sure most people would agree. But what really is a question is, well, can we put it in a contract of employment and or at least say to people, you've got to have a vaccine. If you don't, then we're going to dismiss you, for example. And this is where I brought in the philosophical belief from the veganism case earlier, because there is certainly a risk, and whilst I think Chris and I agree that ultimately the risk could be low in a successful claim, because it would be an indirect discrimination claim and therefore an employer may be able to justify it, and I'll come back to that in a second. There is the whole issue of, you're still going to have to defend the claim, you're still going to, I was going to say time, cost. And the reason I'm saying that is because there's a couple of points here. Firstly, someone could say to you, well, I don't want the vaccine and I think I have a legitimate reason. One is I'm an anti-vaxxer and I believe it's a philosophical belief. You could have a pregnant lady saying, well, medically I've been advised not to have it for whatever reason, or I choose not to have it while I'm pregnant. I haven't seen any cases of this yet, but theoretically you could have someone with a disability, medical condition, who would say, I'm not having it because I believe it may have an impact on my medical condition. And fourthly, for religious reasons, someone may, even though we're being assured that there aren't particular ingredients in the vaccines that will offend certain religious groups, nevertheless, there are people who are saying that. And there'll be others as well, but that's just a few examples of how a member of staff of yours could try and bring a discrimination claim, and obviously an unfair dismissal claim as well if you dismiss them, on the grounds of not having a vaccination. There is also the practical point in, you may get someone saying who has had their vaccination, there's someone next to them who they work with who has refused to have it, and they turn around and say, well, I don't want to work with that person because they're increasing my risk of catching COVID by not having a vaccination. I don't want to work with them. There's a health and safety aspect. So there are a number of things around this at the moment. Now, on the first point, as I say, I think our practical advice, and Chris can chip in here, is that you certainly shouldn't have an automatic blanket. We're going to mandatorily expect people to vaccinate, and if you don't, you'll be dismissed. That is definitely risky. What you could do, though, is have a policy that you're going to potentially vaccinate everyone. But if anyone does have objections to being vaccinated, then obviously you're looking at a case-by-case basis. What do you think, Chris?
No, I agree entirely. I think my approach would be active encouragement rather than making it by requirement. I think Charlie Mullins, as per usual, is putting himself at risk of quite a few claims, as per usual. Yeah, I think maybe the PM's office, what they actually said was taking a vaccine is not mandatory, and it would be discriminatory to force someone to take one, I think was the quote that came out earlier this week. Yeah, as Paul said, whether that legal claim would succeed or not is difficult to say. I think probably not on the balance, but as I'm sure Paul would agree, who wants to be that risk taker?
Yeah, who wants to be the test case? So the second aspect is a bit more tricky, I've even seen suggestions of segregate vaccinators and vaccinators in the workplace, which sounds horrific. That one, I must admit, and all the commentary, and again, Chris, I invite your comment. I haven't seen any sort of really good counters to that. Have you?
No, I haven't, but I'm also not sure maybe necessarily what the claim would be. I don't know how strong the health and safety argument would be for an employee there.
Well, the claim is health and safety, but whether it succeed, like you, I think it's very unlikely. But, and I must admit, unlike the first aspect, I haven't had clients asking about that one yet. That was just more of a debate amongst us employment commentators that could potentially be an argument going forward. So vaccinations, as I say, it's a live case. I don't know if in a minute if anyone wants to come in and talk about that. But do you want to do long COVID first of all, Chris, and then we can open up to general questions?
Yeah, of course. I mean, long COVID, this won't take long, ironically. Obviously, it's started to come out in the news a bit more. Yes, it is a serious and it is a long-lasting medical condition from what we can tell at the moment. I've deliberately used those words because the next natural question arising from that is, could it be a disability? Symptoms are wide-ranging, just as they have been for COVID itself: breathlessness, chest pains. Some people who are suffering from what's being described as long COVID talk about having a brain fog. There have been cases right up to heart failure and possible strokes as a result of complications arising from having long COVID. So yes, I think it probably could well be a disability. It could well tick all of the boxes that it needs to. An impairment for disability purposes doesn't need to be precise. And as we saw earlier, there doesn't even need to be a medical diagnosis per se in the Sullivan case that Paul was talking about. Disability can be determined on kind of its facts more so than its medical definition. The absence of a defined medical condition then isn't necessarily going to preclude a finding of disability. So just because nobody can go, this is exactly what long COVID is, that doesn't mean the condition won't meet the definition. The 12-month requirement could well be met. Of course, it only has to be likely to last 12 months. And again, going back to Sullivan here, the recurrence, the fact that somebody goes through a brief relapse and then suffers from the symptoms again doesn't break that 12-month cycle, doesn't break the disability definition. So yeah, somebody suffering from this for 6, 8, 9 months without any obvious improvement is going to have quite a good case to say that it could last for 12. So what this means in practical terms, I think really is one, making proactive inquiries, especially if you have someone off long-term with flu-like conditions or anything resembling ME has been the best description I've seen as a comparison. Make use of sickness absence policies to explore the condition properly and the symptoms and the effects and on that person in particular. As I say, they might have a cycle of relapses. That doesn't stop it being a disability. Being fine for 6 weeks won't preclude the fact that the condition is still there. Beyond that, it's going to be keeping an eye on symptoms, watch for otherwise completely innocuous policies which run the risk of being discriminatory. I would treat this as an opportunity, if that helps, to explore current practices and see whether they are actually best practice. Just as a prime example, back-to-back or early morning meetings are not going to be great for somebody who is suffering from symptoms that resemble ME, but they're not great for anybody anyway. So that is an opportunity to at least look at what's going on in the workplace and maybe approach it from the point of view of, if somebody does have long COVID, is there a risk of this being a problem for us? It's going to be hard to say. That there's obviously no test case on it yet because nobody's actually had the condition long enough for it to be an issue yet. But I think it is one moving forward, and it is one that is going to need to be very, very carefully managed. And of course, it's going to be one of those cases that it's difficult to prove somebody does or doesn't have without a medical diagnosis for the time being, which I know is a really horrible, blunt, slightly bleak position to finish on. But it's the situation as it is. So that's where I stand on long COVID at the moment.
Yeah. Okay. Thanks, Chris. Right. I'm conscious we've been on for an hour and a half, so but we can open up to general Q&A now. you can either ask in the chat box, or if you are brave enough to come on, unmute and ask questions. I think we have got some in the box.
Is that a raised hand I see?
Yeah, shall I just ask the one in the chat first, and then did you see a raised hand?
All yours. Yeah, go for it.
Yeah, I'll read it out because I'm reading it as I'm looking. I haven't read it. We currently are paying for staff who are off for self-isolation or sickness related to COVID-19 outside of our usual sickness policy. Have you noticed any trends in changes to sick absence policies? I'll let you answer that first.
I haven't personally, actually.
No, I haven't either. No.
I think this has been I think the important thing here is if you're going to do it, obviously make it clear it's discretionary for a start, as it probably is under most people's policy. But of course, make sure you're evenly applying it as well. Yeah.
Consistency is key. Yeah. Sorry.
Hi. Sorry, I was the one that asked the.
Oh, sorry, Angie. Yeah, I didn't want to name you. Yes. Yeah, sorry.
No. So I thought I'd just stick up my hand because what I'm interested in is, at the moment, we have been doing it as a discretionary thing. Obviously, we work in social care, and the well-being of our staff and the risks they're taking at the moment are tricky. We've lost 2 care staff, so we want to definitely do the right thing by our staff. But I guess it's the whole thing of discretionary and how long you could continue to do that for before it becomes part of your sort of custom and practice, or that. So I guess part of my question is whether people were feeling that you can't do it discretionary for much longer, and whether there is a point where you think that it becomes a bit of a risk and we need to actually address our policy.
Well, my thought, and Chris can chip in there as well, my thought is, if you keep reiterating that it is discretionary due to the current pandemic situation, I think that would be a good argument against custom and practice, because we are in such an unusual environment at the moment in terms of COVID. What do you think, Chris?
No, I entirely agree. It's almost like I suppose the best comparison actually almost is to the furlough arrangement. I know obviously that's a written contractual change, but it is clearly stated to only be for the length of, in effect, the COVID situation, isn't it?
Yeah.
I agree. I think keep reiterating that it continues to be discretionary and the reasons for it. And even if there were a claim in the future, you've made it clear that this isn't a contractual change.
Yeah.
Okay, that's really helpful. Thanks very much. Thank you.
Okay. Thanks, Ange. Right. A couple of people have had to go, which is fair enough because we are going past 11. They've thanked us on the chat, but anyone else want to ask any questions? Otherwise,
could I ask a question of Chris?
Sure.
Chris, it's going back to the K&L case.
Yep.
If I may. And you were talking about the reputational damage potential as an allegation and when that's introduced. So I've got a situation at the moment that we've gone through the managing of allegations for an employee that works in a school. He has been arrested but released without any restrictions while the police continue their investigation.
Yep.
We invited him in for an investigatory meeting as part of a separate employer investigation. He was advised by a solicitor not to attend. That's one side of it. But in the specific question here was, when should you introduce the potential risk? Because in my head, it was not until the police did or did not charge him that it might then go into the public sphere, if you like. Is that the right approach, or should it be introduced an awful lot earlier, even? Because I don't know how you would discuss that at an investigatory meeting when you don't even know if that's a possibility yet.
Yeah,
does
of
that
course.
make sense?
That makes perfect sense. I suppose ultimately the question is, if you're going to bring up reputational damage, at what point does reputational damage occur? Yeah, I mean, in terms of a criminal case, it's obviously where it's potentially going to be in the public eye, but we all know that people hear about things outside of police investigations anyway. I think your circumstances, I think you need to be prepared for the fact that reputational harm could occur in the future. It doesn't need to have occurred at the moment.
Okay.
In my opinion, certainly as a point to raise it for investigation, because you're talking about potential harm. You're perfectly entitled to to discipline for potential damage, you don't have to wait for damage to have occurred, I think would be my opinion. I think in order to avoid the same exact issue as in K and L, yes, bring it up as early as you can, because the potential is there. It might be struck out investigation stage because nothing happens. It might be struck out at the disciplinary hearing, but at least the opportunity has been there to address it, I think would be my view. Paul, unless you think anything different.
Yeah. No, I agree. Yeah.
So it's not too late now that it's not been put in the list of potential allegations as yet. We've not had one investigatory meeting with him, so it wouldn't be too late to amend that now.
No, I don't think so. I think the important thing is to always make sure that it's almost like you pull back and do step one again, but within the process, I think is the best way I'd describe it. So just go, here is one we're adding, and it's going to be talked about at the next investigation meeting.
Yeah. Okay. Thank you ever so much. It's very helpful.
You're welcome. I think we've got another hand up.
Is that me?
Is it Ruth?
Yep.
Yeah, hi there.
Hi.
Sorry, this is a Brexit question, I'm afraid. Sorry about that. We make furniture in the UK, so that's made in Christchurch, and we sometimes go over to France, Norway to fit it, and we would send a site fitter over, often self-employed, to go over. It might be a day, 24 hours, or it could be up to a week, no more than that. Do you know whether that's something that we would need to get a visa on? I know it's a bit unclear at the moment, but we're trying to...
Did you say Norway?
Yeah, sometimes Norway, and I know that it's different between country and country, so that'll be something.
Norway's not.
Yeah. But mainly it's France, which can have difficulties because it's different between different states in France. But is that something? Where I have read is that sending over a self-employed and contractor might be an issue, so it might have to be an employee. And is it something that we need to be looking at a work permit for a short day, so up to 90-day visa potentially? I don't know whether you know any more.
And this is so this is in the country they're going to, isn't it?
Yeah, so this is the country they're going to. They're purely just to fit it for the end user.
Chris, my understanding is it's the country's, even though they're in the EU, it's the country's rules, isn't it?
Yeah, we're a third party now, so yeah. I mean, my knowledge of immigration rules is slightly limited. I think you're probably going to have to look to either the FCO for advice or probably an immigration specialist, if not a lawyer in that country. I'm afraid.
Or the border agency, whatever the name. Yeah.
Okay, that's fine.
Sorry about that, but
no, it's fine.
It's going to be Norway or France or whichever country's own rules on that. So you almost have to find, dare I say, an expert on that country who will, or as Chris said, someone like the FCO or the border agency.
Yeah. Okay. Fine. Fair enough. Thank you very much.
Okay.
Sure.
Sorry.
That's all right.
Any other questions? Oh, hang on. No, the chat is just people kindly thanking us. They're obviously leaving. There's anything else? Sorry,
I did have one more, but I don't want to take up all your time and be very needy.
No, go for it.
To what extent can you use personal thoughts and views that were disclosed to a head teacher about the students that an employee worked with in an occupational health referral if you've got safeguarding concerns about the thoughts that they relayed? And this is the difficulty. So they were fairly concerning thoughts he described just to the head teacher towards not just the school, but the pupils that he was working with in the setting. Very, very concerned about what this was, what he said. So we want to go back to occupational health to assess his well-being. But trying to get across the very reason why you need to get that referral to occupational health because of the thoughts that he presented. How much can you use of that level of conversation when you are doing an occupational health referral? So how much is sort of protected under sort of GDPR or any other kind of confidential issues if you have got genuine safeguarding concerns? And we did check out the safeguarding concerns with the LADO, and they agreed that there was potential safeguarding concerns if he was in the setting, which he's not at the moment. But it's that conflict of what can you use when you're doing an occupational health referral if you've got those kind of concerns.
Yeah, because of course there's two elements to that, isn't there? There's, as you say, the safeguarding issue concerning the child individually, and also the confidential information result, about the member of staff. They're almost two different data protection issues, aren't they? In terms of, again, not a data protection specialist. I think in terms of from the child's point of view and the safeguarding issue, you're going to know this as well as we do. I think you're going to be able to clear that off with presumably parental consent in this circumstance to share that if it deemed necessary. From the member of staff's point of view, the occupational health report is generally intended as we know, it's expected to be something that's mutually beneficial to the employee and the employer. You can generally share, in my experience, whatever you need to within there, providing you've got that individual's consent in the first place, because of course it could well be highly confidential information, as in this case. I think purely from a data protection point of view, it's going to be ticking the GDPR boxes for the legitimate reason for processing it. And I think if you can get explicit consent from everybody concerned for the specific details, that's going to be your only way around that. But again, I'm not a GDPR expert.
Okay, yeah.
Can I just, did you say it was thoughts that, and what the head teacher had heard them, or was anything put down in writing?
Oh, he put it in writing. He sent, he sent he sent a 3-page letter of his thoughts after this meeting.
Right. Okay,
lots and lots of thoughts.
When you said thoughts, I just wanted to check.
Yeah, but a couple of those thoughts were direct.
Yeah.
They were directly about the feelings he had towards some of the children he worked with that were very concerning. Yeah. Put it that way.
Okay, I've got another question here.
Thank you.
Thank you. Yes. If people facing redundancy in a 45, so I'm just reading this out straight. If people are facing redundancy in a 45-day consultation process, so it must be at least 100 people, request to shorten, and the staff request to shorten the process, and the employer accepts, can that be still considered a breach at a later date?
I'll give you that one. I did GDPR.
Well, the answer potentially yes, if because the 45-day is a legislative protected period.
Statutory right, yeah.
It is potentially a breach, or could still be a breach. Where it will come into the factor is obviously there is discretion on any protective award, and obviously if the employer can show that the employee basically asked for it to be shortened, then that will obviously be a relevant factor if and when determining any protective award. So technically it's a breach, but you'd hope that any reward would be reduced down perhaps into zero. Do you agree, Chris?
Yeah, absolutely agree.
Sorry, I just,
sorry, no, I agree with you entirely. It's because I can see Jane waving at us.
Oh, right. Oh, so I'm not getting that. It's because I still got your shared screen. That's why. I can't see the hands. So.
Thank you, Paul. And it was my question. And so the supplementary question to that is, if we're all in agreement, would it then be appropriate that we don't make any financial detriment for the shortening of the 45 consultation if we accept that? So, for example,
I see what you mean. No, I think I see what you mean. You're going to have people employed for a shorter length of time, basically, aren't you?
Well, so potentially your notice, if you're not working your notice period may have started on the 3rd of March, but if somebody's asking to go on the 3rd of February and we accept that we're letting them go early, should we also, from a protective breach position, just suck up the extra 4 weeks pay and pay them what they would have been paid had they stayed the course for 45 days? Consultation.
Yeah, see, I think I'd be inclined to wrap this in a settlement agreement personally.
For sure, sure. But the content of the settlement agreement.
Yeah, that's what I mean. You're not obliged. Obviously, you're not obliged to for the purposes of the settlement
that's what
agreement.
I was going to say. Because obviously I know the situation.
Well, it's another one, you see, Paul.
Yeah, because ultimately, well, there's even arguments if they're asking to go early and stuff. Then there's, I'd hope they wouldn't bring a claim, because there's even arguments here that they're asking that they're resigning early. I know we're not going to argue that, because that opens up a can of worms. But It's practical to do the extra 4 weeks.
It buys us out of any claim.
I was going to say, it's not a legal answer. It's just it's a practical answer.
How nice do you want to feel? Yeah.
Yeah, exactly.
Okay, that's great. Thank you.
Yeah. Sorry.
All right. Thank you.
Any others? Because I'm conscious. Yeah, we've lost some people. We've lost.
Yeah, we're coming up to 2 hours, aren't we?
What I was going to say with you, those of you who kindly stayed right to the end, well done, because I know some of it would have been dry. Obviously, you'll know about, because you obviously come to this, so you know about the event invites. Hopefully, you'll get in our newsletter articles. Chris and I, although it's been a bit quiet lately because there hasn't been so much on it, but certainly last year through all the furlough updates, we do put any sort of urgent updates on LinkedIn. So if you're not already connected to us on LinkedIn, that is worth doing. As I said at the beginning, we will be sending out the recording of this to everyone. So no worries if you, I know some of you are frantically taking notes, you can go back and obviously listen to it later. And we will also send out follow-up emails as well regarding some of the topics that we've been discussing today. Certainly things like the long COVID and vaccinations, I know we are looking at in more detail. So just to say thanks again for joining us. All stay safe, and hopefully we will see you soon, and hopefully one day it will be face to face again for lots of us, those of you who are local to the area anyway. Okay, thanks then.
Yep, thanks everybody.